Now we move on to the next topic of our module, that is Indian law and environmental crime prevention. Implementation of international environmental law requires that international legal mechanisms are established and enforced at a national level through appropriate legal regimes. This means that the nation state should take proactive legislative and judicial actions within the states to achieve the compliance with the internationally agreed rules and standard. The environmental crimes in India are mainly categorized into 5 categories as offences against the following 5 national laws: the Forest Act 1927, the Wildlife Protection Act 1972, the Water Prevention and Control of Pollution Act 1974, the Air Prevention and Control of Pollution Act 1981, and the Environment Protection Act 1986. First, we will discuss the Forest Act 1927. The Forest Act 1927 reflects the British interest of commercial exploitation and economic utilization of the resources. The Act reflects the British policy of commercial exploitation and economic utilization rather than the conservation of forest resources, and it provides for the penalties for the violation of its provisions under Section 33, 41 and Chapter 9. The offence against forest is defined under Section 2, Subclause 3 as an offence punishable under the Indian Forest Act 1927 or the rules promulgated thereunder. However, the penalty provisions under the Act is very low, where it says the penalty is imprisonment up to 6 months or a fine of 500 rupees or both. Forest offences have been classified into 2 broad categories. There are trivial offences covered under Section 68, where the offences are disposed by compounding of offences. Secondly, there are offences which do not fall under the above category and which attracts the punishment which we discussed just now, that is 6 months imprisonment and 500 rupees. So, when we talk about Forest Act, we have to realize that even though it doesn't have a conservation and management perspective, the penal provision has prevented many crimes or interferences in the forest area. The Forest Conservation Act was enacted with the twin objectives of restricting the use of forest land for non-forest purposes and preventing the dereservation of forests that have been reserved under the Indian Forest Act. The Act empowers the central government to constitute a committee to advise it with matters connected with the forest conservation. Section 3A of the Act provides for the penalties such as imprisonment extendable up to 15 days for violation of the provisions of the Act. Now we will discuss the Wildlife Protection Act 1972, which was the first comprehensive act of the country enacted to provide for protection of listed species of wild flora and fauna and establishes a network of ecologically sensitive and important protected areas. The Act provides provisions for protecting, propagating or developing wildlife and its habitat. The Act is notable for its no-fault liability. That means mens rea is not required to be proved for punishing an offender. The punishment of any offences under the Act are given in Section 51 of the Act. Maximum punishment is provided for offences related to animals specified in Schedule 1 or Part 2 of Schedule 2. Hunting within a national park or a sanctuary, altering the boundaries of a national park, or hunting within a tiger reserve attracts the highest punishment under the Act. The next Act we are discussing is Water Prevention and Control of Pollution Act 1974. Enacted in 1974 to provide for the prevention and control of water pollution and for maintaining or restoring of wholesomeness of water in the country, the Act functions on the basis of the concept of consent under Section 25. The Act primarily says that a person cannot discharge any waste water, maybe it might be trade effluent or a sewage effluent, into open without prior consent of the Pollution Control Board. The penalties are provided under the Act for violation of its provisions under Section 41, 42, 43 and 44. The next Act, the Air Prevention and Control of Pollution Act 1981, was enacted for the prevention, control and abatement of air pollution. The Air Act also functions on the basis of prior consent. However, the penalty provisions were added later to the Act in 1987 amendment. Sections 37, 38 and 39 provides for the penalties under the Act. Now we come to the next important act in Indian legal system for protection of environment, that is Environmental Protection Act 1986. The Environment Protection Act 1986 was passed by the Indian Parliament for implementing the decisions of the Stockholm Conference. It is the general environmental legislation for a comprehensive legal regulatory system in India. Section 3 provides the power to the central government to take all measures that are necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling and abating environment pollution. The Environment Protection Act under Section 15 gives the provision for punishment or penalties for the violation or non-compliance of the provisions of the Act. It provides for the punishment of the following instances: non-compliance or violation of the Environment Protection Act 1986, non-compliance or contravention of the Environmental Protection Rules 1986, and other directions or orders under the rules. The Environment Protection Act provides with a punishment with imprisonment for a term which may extend to 5 years, or with fine up to 1 lakh rupees, or with both. In case of continued violation, an additional fine of up to rupees 5,000 per day might be charged. When it comes to the hazardous substances in India, the Environmental Protection Act provides for various rules under which the handling and management of such substances are regulated. The major rules in this regard is the Hazardous Waste Management, Handling and Transboundary Rules 2008, Manufacture, Storage and Import of Hazardous Chemicals Rule 1989, Hazardous Microorganisms Rule 1989, etc. The rule makes the handler and the transporter liable for any consequences of handling such hazardous substances in India. The violation of these rules will attract the penal provisions of the Environment Protection Act 1986. The next act we are going to discuss is the Biological Diversity Act 2002. The Biological Diversity Act 2002 was passed to provide for the conservation of biological resources, sustainable use of its components, and fair and equitable sharing of benefits arising out of the use of such biological resources and knowledge. Compared to the previous legislations which we have discussed, the Biological Diversity Act provides for higher level of penalties. It provides for penalties under Section 55, 56 and 59 for violation of rules regarding permission to obtain natural resources, transferring research results, and IPR applications without permission. The penalties under the Act are imprisonment up to 5 years, or fine up to rupees 1 lakh, or if damage exceeds this amount, a commensurate amount is also fined. The obtaining of biological resources without permission, the punishment is imprisonment up to 3 years and fine up to rupees 50,000. Now we come to the authorities and institutions for enforcement of environmental laws. We have seen that environmental crime has an international character, and this means you need an international regulatory agency. So the Interpol has actually filled up this position internationally in the last decade. Interpol is the world's largest international police organization. It facilitates international police cooperation and provides technical and operational support to all police forces. Interpol has identified environmental crime as one of the 19 priority crime areas, and it focuses on illegal wildlife trade, pollution crimes, and the emerging types of environmental crimes like carbon trade, water management, etc. And when we come to the national level, the major authorities or institutes which are engaged in the activities to prevent crimes against environment are the Ministry of Environment, Forest, the Ministry of Environment, Forest and Climate Change, the Central Pollution Control Board, State Pollution Control Board, State Departments of Environment, municipal corporations, enforcement agencies like Central Bureau of Investigation, Wildlife Crime Control Bureau, and the local police authorities. The Wildlife Crime Control Bureau and National Crime Records Bureau supports in the documentation of the reported crimes against environment. The customs also have a major role to play when it comes to international environmental crimes, especially illegal trade in wildlife and forest produces. Now we move on to the last part of our module, that is a select judicial decision. Indian judiciary had garnered international respect with regard to the extensive interpretation of Article 21 of Indian Constitution, which grants right to life and extending it to include right to wholesome environment. The first major case which we have to discuss is the oleum gas leak case, which invoked the concept of absolute liability. The Supreme Court stated that an enterprise which is engaged in a hazardous or inherently dangerous activity posing a potential threat to the health and safety of the persons working in the factory and residing in the surrounding areas owes an absolute and non-delegable duty to the community to ensure that no harm results to anyone on account of hazardous or inherently dangerous nature of the activity. Second case is Vellore Citizens Welfare Forum versus Union of India. This is a 1996 decision where the Supreme Court imposed a pollution fine on the company for causing river and land pollution. The fine amount was to be utilized for restoring the damaged environment and compensation for the affected persons. The next case is Sterlite Industries India Limited versus Union of India, a 2013 decision which garnered international attention due to the compensation awarded in this case. The company carried out copper smelter plant activities in an ecologically sensitive area without permit. The court applied the concept of absolute liability for pollution of air, land and marine area and awarded a compensation of ₹100 crores. The next case is Sansar Chand versus State of Rajasthan, which was decided in 2012. The Supreme Court in this case held that it is not always possible to get direct evidence against the gang leader. In such instances, their involvement can be proved and they can be convicted or punished on the basis of oral evidence or extrajudicial confession corroborated by other evidence. Now we have come to the end of the module. In this module, we have discussed international legal frameworks and domestic legislations for prevention of environmental crimes, and we have also mentioned select judicial decisions by the Indian judiciary in the topic. Now we come to the end of the module. In this module, we have discussed various international legal instruments and domestic legislations which deal with prevention of environmental crimes. We also looked into select judicial decisions which dealt with the issue. I hope this module would be useful for you and it would help you in your further studies. Thank you.